Good morning. Continuation of our search incident to an arrest section of exceptions to the warrant requirement. We'll now deal with searches incident to an arrest of an occupant of an automobile. That line of cases started with New York versus Belton. And just in a nutshell, New York versus Belton says that a police officer who makes an arrest of an occupant of an automobile may search the automobile and may search any containers within the automobile. In New York versus Belton, officers stopped an automobile with four men for speeding. The officer asked for driver's license and car registration and found that none of the men were related to the car's owner. Officers smelled marijuana and recognized an envelope on the floor with the words Super Gold, which associated it with marijuana. He ordered the men from the car and patted them down. He retrieved the envelope and found that it contained marijuana. After giving the suspects their Miranda warnings, he searched the passenger compartment of the car and found the defendant's jacket, which he also searched. In the jacket, he discovered cocaine. The question became whether the officer could search incident to an arrest and whether he could search not only the occupants of the car and also the interior of the car. The court found that incident to an arrest, that the officer may search the occupants of the car, that he may search the occupants, and it's not limited to the search of occupants, but he may also search the interior of the car. And the interior of the car includes any containers that may be found in the car. And the court went on to define the container, to state what a container is. The court said the container here denotes any object capable of holding another object. It includes the glove compartments, receptacles, consoles, etc. And so, for the most part, if an officer arrests an occupant of the car under New York versus Belton, he has the right to search that car, the interior of that car, and any containers within that car. This does not include the trunks. This is exclusive of the trunk. The court said, we hold that when a policeman has made a lawful custodial arrest of the occupant of an automobile, he may, as a contemporaneous incident of that arrest, search the passenger compartment of that automobile. The police may also examine the contents of any container found within the passenger compartment if the passenger compartment is within reach of the arrestee. So will containers in it also be within his reach. The court found that this was an extension of Shamel. That is, the occupant of a car had access to the car, and thus, because he had access to the car, the officer will allow him to get back into the car. Then that became the spatial area or the grab area. And because it was the grab area that the officer had the right to search that particular grab area, here being the car. But again, it had to be an occupant of the car who was subject to an arrest. And this became a per se rule. Remember that if you go back and listen to the tape or listen to the video dealing with Shamel was a case-by-case rule. It was not a bright line per se rule. But here, New York versus Belton says an officer automatically, if he arrests an occupant of the car, that he can search the occupant. Not only can he search the occupant under New York versus Belton, under U.S. versus Belton, but he also, under Shamel, can search the interior of the car and any container within the interior of the car. Again, this is a bright line rule as it applies to automobiles. If we continue and we look at the next case, has a trilogy of cases that deal with New York versus Belton. The next case after New York versus Belton in that trilogy deals with Thornton versus the United States. In Thornton versus United States, the officer stopped Thornton after he had parked and asked him for his identification. Thornton appeared nervous. Thornton agreed to a pat-down. Officer removed crack cocaine from Thornton's pocket. Thornton was placed in the back seat of the patrol car and an officer searched the vehicle. A handgun was found under the seat. The court found that Belton applies even when the officer does not make contact until the person arrested has left the vehicle. In all relevant aspects, the arrest of the suspect who is next to a vehicle presents identical concerns regarding officer safety and the destruction of evidence as the arrest of one who is inside the vehicle. The stress of the arrest is no less merely because the arrestee exited his car before the officer initiated contact, nor is the arrestee less likely to attempt to lodge for a weapon or destructible evidence if he's outside of, but still in control of the vehicle. Belton permits the search of a passenger compartment if there's an arrest of an occupant, recent occupant of the vehicle. And that's what uh, Thornton added. Thornton said that it's not necessarily just an occupant of the vehicle, but there has to be a recent occupant of the vehicle. And thus, the officer has to show that the person was a recent occupant of the vehicle. He could not come and find the uh, person who is standing outside the vehicle and just and, and not necessarily has access to the vehicle, but is walking away from the vehicle with the gas can, and then arrest that person for something and then go back and search the vehicle. He must be able to show that the person, according to Thornton, was a recent occupant of the vehicle. Another important part of Thornton, though, was the opinion, the concurrent opinion done by Scalia. I'm sorry. Scalia says that, hold it, we're correct as far as what we found, but the way that we found, the way we went by it is not correct, is not proper. He said that the basis of the court decision is a ruse. A Belton search is not an automobile extension of Shamel. And so he says, look, this is not an automobile extension of Shamel. The Belton search is not justifiable because the arrestee may grab a weapon or evidence from his car, but simply because the car may contain evidence relevant to the crime for which he was arrested. He's going back to an older case, which is called Rabinowitz. Hence, the possibility of the arrestee retrieving a weapon or evidence was nil. He was handcuffed in the back of the cruiser. The Belton search is better explained by the ruling from Rabinowitz, wherein the court did not treat the fact of arrest alone as suspicion, but upheld the search only after noting that it was not general or exploratory, but related to a reasonable belief that evidence would be found. Scalia also believed that Belton was not even an extension of Robinson, because Robinson is based on the fact that the arrest alone justifies the arrest. And so what Scalia is saying is that, look, we've got this messed up. That is not an extension of Belton. That Belton allows you to arrest a recent, that Belton, I'm sorry, is not an extension of Shamel. That Belton says you can search the grab area as an extension of Shamel. He says that what we should be looking at is the fact that the person has arrested a person who is a recent occupant of the car. If he's arrested someone who's a recent occupant of the car, then he has a right to search that person for evidence of crime that will relate to that arrest. And thus, we should look at Rabinowitz in order to define, in order to guide us on how to deal with these questions. And that concurrent opinion by Scalia became very important in the next case of Arizona versus Gantt. In Arizona versus Gantt, police officers stopped Gantt for driving with suspended license. He handcuffed Gantt and he locked Gantt in the backseat of the patrol car. Police searched the car and found cocaine in the jacket pocket of a coat on the back seat. The question became, at this particular point, whether Belton applied, whether Belton and Thornton applied. We can prove that Gantt was a recent occupant of the car. However, in Belton, it appears that the underlying circumstances, the underlying justification for Belton was that it was within his grab space. It was an area from which he can lunge to grab destructible evidence, or he can lunge and he can grab a weapon. The court went on to say, and what they did here, really interesting, they adopted Scalia's concurring opinion and made Scalia's concurrent opinion tie along with Belton. And so they tied Thornton and Belton, Scalia's concurrent opinion from Thornton, along with the Belton opinion. And what the court actually said, what they actually did was, they said that if officer arrests a recent occupant of a car, that he can search the occupant, that's under Robinson, but he also can search the interior of the car and in a container if the occupant of the car has access to the car, because at that particular point, he presents a danger to the officer because he will get back in the car and he will have control of the car and he can grab a weapon from which he can use to harm the officer, and they can search him under that. Or if they can't prove that the person has access to the car, even though he's a recent occupant, if he cannot prove that he has access to the car, he can also search the car. The officer can also search the car if the if he can show that he's looking for evidence of crime for which the person has been arrested. And so you look at the crime for which the person has been arrested and you determine what the officer can look for. And if that evidence would be found in that car, then he can search the car. For instance, if you arrest a person for possession of cocaine, then evidence of cocaine can be found in the car. If you arrest them for being involved in an armed robbery or recent burglary, evidence of a burglary or armed robbery can be found in the car. And thus, because he arrested recent occupant of the car, he can search for the purposes, for armed robbery. He can search the interior of the car also. It's really, if you go back and you apply it to the facts here, you apply it to the facts of Gant, they could not search the interior of the car because what reason did they stop Gant? They stopped Gant for a suspended driver's license for a traffic violation. And what happened with Gant? They handcuffed Gant and it placed him in the interior of the car. Once they placed Gant into the interior of the car, he no longer had access to the car, and thus there's no threat that he can lunge and get destructible evidence or a weapon which he could use against the officer. Thus, the spatial area part of the decision does not apply. Also, if you look at the purpose, again, look at what he arrested him for. He arrested him for a suspended license. Evidence of this crime of a suspended license is not going to be found inside of a car. You're going to find that on the person. You're going to find that in his records. And thus, number one, he's handcuffed. He doesn't have access. Number two, he's arrested for a crime, a traffic violation, and it's not reasonable that you're going to find evidence of that particular crime within the car. Therefore, the search was a violation of the Fourth Amendment. The court said, the Chanel rationale authorizes police to search a vehicle incident to a recent occupant's arrest only when the arrestee is unsecured and within reaching distance of the passenger compartment at the time of the search. We also conclude that circumstances unique to the vehicle context justify search incident to a lawful arrest when it is reasonable to believe evidence relevant to the crime of arrest might be found in the vehicle. The offense of arrest may supply a basis for searching passenger compartment of an arrestee's vehicle and any containers therein. Neither the possibility of excess nor the likelihood of discovering offense-related evidence authorized the search in this case. The 5 officers outnumbered the 3 arrestees, all of whom had been handcuffed and secured in the back of the cruiser. Gant clearly was not within reaching distance of the car at the time of the search. Any evidentiary basis for search was also lacking in the case. Gant was arrested for driving while with a suspended license, an offense police could not expect to find evidence of in the passenger compartment of the car. Thus, the court said that, again, the arrest was not, a search was not proper. It was in violation of the Fourth Amendment. So you need to remember Gant. You have to remember Belton. The Belton really is the Belton-Gant analysis. If police officers arrest a recent occupant of the car, you have to show that he's a recent occupant of the car. They arrest a recent occupant of the car. They can search the interior of the car and any containers in the car, and containers anything that's capable of holding something. And evidence found as a result can be used against them. However, they can only search the interior of the car. They can only search the interior of the car under 2 circumstances. Number one, if the person still has access to the car. That is, if the person is handcuffed and he's placed in the back of the cruiser, the person is handcuffed and he's placed on the side of the road, he does not have access to the car. Or if it is reasonable to believe that evidence of the crime related to the arrest can be found in the car. Hence, there must be an arrest. There must be an arrest. And one of those 2 elements must exist in order for the officers to search the car. Again, it's limited to the interior. You can only search the trunk of the car under 2 circumstances, and we'll talk about that a little later. They're going to be consent and the automobile search, the true automobile search, or the what we call the inventory search, which is not really a search. Moving on, looking at Iowa versus Knowles. In Iowa versus Knowles, uh, Mr. Nose was arrested for speeding, and he was issued a citation rather than arresting him. Now, the officer could have arrested Mr. Nose, but he chose not to arrest him, but he issued him a citation. After he issued him a citation, without Nose consent or probable cause, he searched. Uh, he did a full search of the car, and he found cocaine, marijuana in the car, and a pot pipe, the case says. The question became whether he could search that car even though he did not arrest, and even though also he stopped them for an arrestable offense. Here he could have arrested him, but he chose not to arrest him. Knowles says that a search incident to an arrest only applies if there is an arrest. That an arrest must occur in order for the officers to engage in a search incident to an arrest. That is, a search of the car here, or even the search of the person. Well, the search of the car here, because it was actually an arrest for a traffic violation. And so that the rest of that search of that car is going to occur. That person must actually be arrested. Doesn't matter that he could have arrested him. He must have arrested him in order to conduct that search. Very interesting in light of a case that followed Iowa versus Knowles. Iowa versus Knowles came out. Don't have the date on it, and I'm believing it was around the early 2000s that Iowa versus Knowles came out. But in 2008, Virginia versus Moore, another case that dealt with the search of a car. Really interesting case. Police officers stopped Mr. Car driven by Mr. Moore, and they had overheard that the person who was known as Chubbs was driving with a suspended license, and one of the officers knew that this nickname was associated with Mr. Moore. The officers determined that Moore's license was in fact suspended and arrested him for a misdemeanor of driving on a suspended license, which is punishable under Virginia law by citation only. It's only by citation that is punishable. It says here, which is punishable under Virginia law by a year in jail or $2,500. The officer subsequently searched Moore and found that he was carrying 16 grams of cocaine and $516 in cash. Under state law, the officer should have issued a summons instead of arresting Mr. Moore. Here, they could have arrested him, and they did arrest him. However, under the state law, because it was a first offense, I believe that's what it was, that they should have issued a summons to him, and then they should not have arrested him. And if they could not arrest him, then they could not search the car because we don't have a search incident to arrest. And it went on to say, the intermediate court or the district court found that the arrest was good. The intermediate court said that it was not. The Supreme Court came back and approved or reinstated what the district court said, that the arrest was good. Virginia permits an arrest for driving on a suspended license in jurisdiction where prior general approval has been granted by order of the general district court, is what the district court said. I'm sorry, what the appeals court said. But the Supreme Court says that he had the right to arrest him, and thus, under the law, even though he had not been issued the right to arrest him, under the law he had the right to arrest him, under the statute he had the right to arrest him, but there was something that was added that the arrest for that violation, that traffic violation, could only occur if there was a general order by the district court. Let me see if I can make certain I clear the facts up. Then we can understand it. Stop them for a traffic violation. Traffic violation, generally, that traffic violation of speed, the traffic violation of not having a license, a driving with a suspended license, generally was taken care of by citation. The person is generally not arrested. Here, he arrested him. However, the statute says that the fine for it is arrest or $2,500. That is 1 year in jail or $2,500 fine. However, in order to execute the arrest, there must be authority under Virginia law given by the district court in that area. The district court in this area had never given authority for the purpose of arresting a person for driving under suspension. Thus, the officer did not have a right to arrest him in this particular district because there was no authority given by the district court under that law. Mr. Moore filed at trial filed a motion to suppress based on the fact that the arrest violated the Fourth Amendment. He said there was no probable cause for the arrest. There was no probable cause because there was no statute that actually gave the officer the right to arrest him, because the district court had not given authority under the office, under that article, under that statute, to arrest that person, to arrest a person that was found in violation of this particular statute. Therefore, he said that I was illegally arrested in violation of the Fourth Amendment. The Supreme Court went on to say, it's really interesting what the Supreme Court said. In a long line of cases, remember, he was not arrested. He was not arrested. It was not an arrestable offense. Go back to Noel versus Iowa. Even though it's an arrestable offense, the person has to be arrested. Here he was arrested, but it was not an arrestable offense. In a long line of cases, we have said that when an officer has probable cause to believe a person committed even a minor crime in his presence, the balancing of private and public interest is not in doubt. The arrest is constitutionally reasonable. If an officer has probable cause to believe that a person has violated a minor crime, even a minor crime, in his presence, he has the right to arrest him, even a misdemeanor. He has the right to arrest him, and that arrest is going to be constitutionally valid. Doesn't matter what the state law says. It doesn't matter what the requirements of the state law are. The Fourth Amendment gives him the right to arrest if he has probable cause to believe that the person has engaged in a crime. When officers have probable cause to believe the person has committed a crime in their presence, the Fourth Amendment permits them to make an arrest and to search the suspect in order to safeguard evidence and ensure their safety. No evidence can be safeguarded here. There was no question of safety, but the court went on. We conclude that the warrantless arrest for crimes committed in presence of an arresting officer are reasonable under the Constitution, and that while states are free to regulate such arrests however they desire, state restrictions do not offer the Fourth Amendment protections. What it says, the Fourth Amendment protections trump state laws. I understand that, but the state laws can give their citizens more rights under the Fourth Amendment, but they can't give them any less rights. They can give them more rights. And here it appears that the state law gave them more rights. But what the court is saying, what happened here was Mr. Moore filed his action on the basis of a Fourth Amendment, on the basis of a Fourth Amendment protection. And if you're going to apply the Fourth Amendment protection, you apply the law that deals with the Fourth Amendment. And the law that deals with the Fourth Amendment says that an officer that has probable cause to arrest can arrest a person if he has probable cause to arrest. An officer who has probable cause to believe that a person has committed a crime in his presence has probable cause to arrest that particular person. And here the officer had probable cause to believe the person has committed a crime in his presence because the person did not have a driver's license. He was driving with a suspended driver license. And regardless of what the state court says, that this is not an arrestable offense unless some special things happen, it is still a good arrest. It is still a good arrest because the Fourth Amendment permits it. And so basically what you're saying is that an officer can search a person if he arrests a person for an offense that is not an arrestable offense, and he has probable cause to believe that it's an arrestable offense. It's kind of, it twists things, people. It really twists things. And so we're going to stop here. We're going to move on with our next video. and I'll post this video and I'll send the links to you. Thank you so very much. Goodbye.